Hello everyone, back to me Arya Aditya from the School of International Studies as an international affairs student. So my field explains a lot about international law concept, especially the international regulations to use of force. You know, I just want to ask you, did you think it's necessary for us, or did you think that's very important to us to know about that? It's back to you, but I just want to remind you about we are facing to a food crisis, the energy crisis, the climate change in this century. I guess it's a scary situations and conditions in this century. You know why it happened and what the major reasons it happens. It happens due to, for example, the one of indicator of that is the inventions like the country use their power to against another country. But anyway, you have to know about the terms of jus ad bellum. Jus ad bellum is the terms that mentions about we can do a war with some conditions, or it's mean it depends of the situations, like for example self-defense and so on. In the philosophical concept, there is a terms of the axiology. I think like jus ad bellum has the same axiology or goals with a terms of a preemptive strike. Preemptive strike, if you did you ever heard about that? Preemptive strike is the terms that a country can against another country to protect about the sovereignty and the international state. There is three models of the preemptive strike. The first, economic or the economic embargo, the politics like soft diplomacy, and the last one is the military, or as we know that there is a common war. Critical reality, the example of that is the 9/11 tragedy. I mean like when the World Trade Center tower it's against from terrorists of the Al Qaeda. So in this case, United States did preemptive strikes to again the Middle East country, for example, or the another case it's the not South Korea, but North Korea. So like Japan, like United States, and also the United Nations, it's the economic embargo to North Korea. You know, the preemptive strike is born from the George Bush Washington paradigms when the 9/11 tragedy happens in United Nations.
Hello, my name is Priti Maulidya Pralena. My matric number is 283089. Today I would like to talking about the international regulation of the use of force. The use of force has been a long-standing phenomenon in international relations and has been considered to be directly linked to the sovereignty of states. In the international community, force has featured as at high levels of decentralization, like force has been used for different purposes. It has been applied to previous intervention and to punish for non-compliance according to demand. War is the hardcore form of force and is used to grab territories or completely suppress states. Reprisals are also considered as violence in international relations. With the founding of the United Nations, the legitimacy of the use of force by individual states under international law has been substantially narrowed. The Charter of the United Nations states in its preamble that the United Nations is established to save succeeding generations from the scourge of war, and its substantive provision obligate the member states of the United Nations to settle their international disputes by peaceful means and to refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any manner inconsistent with the purposes of the United Nations. It is clear that the use of force is certainly prohibited in the view of territorial integrity and independence of member states, including armed force intervention. Thus, it is certain that the United Nations does not condemn any form of reprisal. This is completely out of its purpose. The use of the term force clearly indicates that The traditional perception on war and the modern definition are prohibited. However, there are certain situations in which it is allowed to use force, such as for self-defense purposes, humanitarian intervention, and preemptive power. In a matter of self-defense, this is provided in Article 51. International law allows the use of force in self-defense or protect the right of a state. However, there are several criteria which should be in a state before the state use force to protect itself, which are necessity, proportionate, sovereign peace, imminent attack with accurate information. This can be explained well by the Carolines case. This case sets out the customary international law definition of the right to self-defense. It originates from a dispute between the British government and the U.S. Secretary of State regarding the destruction of an American vessel in an American port by British subjects. The reason behind this act was the use of the vessel to transport munition and groups of Americans who were conducting attack on the Canadian territory. The U.S. government declared that the attack on the vessel constituted an attack against the American territory. The British government responded by claiming the right to self-defense. Eventually, to this day, the Carolines case is considered the customary law standard in determining the legitimacy of self-defense action. That's all from me. Thank you.
Hi, I'm Nabila Honoris with metric number 28746. Now let's talk about reprisal. Have you ever heard what reprisal is? So the definition of reprisal is a coercive effort made by a country against another country with the purpose of resolving disputes that arise because the country subject to reprisal has committed unacceptable actions. Reprisal can be justified if it's in accordance with the legal provisions applies and does not violate international humanitarian law. And reprisal is a limited and deliberate violation in international law. 51 of the UN Charter. In times of conflict, reprisal are considered legal under certain conditions. They must be carried out in response to a previous attack. They must be proportionate to the attack. They must be aimed only the combatant and military objective. Now the case between Portugal and Germany. This is the classic case 1 for the example where retaliation was used. This incident began when 3 German officers were killed in the England fortress for not allowing the German military invaded the England colony. Then they destroyed property and retaliation for wrongful killing of 3 Germans in Portuguese territory. Even though states are not allowed to use force to settle their disputes, military retaliation can be legalized if carried out in accordance with the right to self-defense, or if the UN Security Council permits the use of military force to protect international peace and does not violate humanitarian law. The no-lila case is usually connected with the requirements of a lawful. Reprisal 1 is a prior act contrary to international law. Second, unsatisfied demand for reparation to the alleged wrongdoer. Third, the proportionality of the reprisal. The arbitration held that these requirements were not met by Germany when it attacked the Portuguese fortresses in 1914. Thank you.